Cypres is an interpretable doctrine which allows a court to amend a legal document to enforce it as near as possible to the original intent of the instrument. In situation where it is impossible, impracticable, and illegal to enforce it under the original term. Cypres allows a court to revise a charitable trust. In order to apply the Cypres Doctrine, a court must determine that the following condition has been met. 1. The settlers have made a valid charitable trust. 2. The terms of the charitable trust are not impossible to perform. 3. The settler has a general charitable intent.
Judicial authorities under Cypres Doctrine, in the case of Attorney General versus Ironmonger Co. 1844, the fact of the case was that a testator left money to redeem British slaves in Turkey and Barbary. Over time, piracy decreased and the British slaves no longer existed in those regions, leaving a massive surplus of trust funds. The House of Lords held that since the primary object fails through a total lack of beneficiaries, the court must apply the funds to other charities. The court reallocated the funds to supporting charity school, establishing that when a specific charitable target disappears, equity will provide the access to a broader surviving charitable issues. In essence, the charity is preserved, but its mode of application is modified.
Buckley versus Monk. A testator devised real estate to be used to build a home and a school for each and destitute person for a specific locality. But the property itself proved entirely inadequate and unsuitable for such a massive architectural undertaking. The Supreme Court of Missouri held that when the specific parcel of land or exact mechanic designated by a donor fails due to fiscal or financial inadequacy, equity will invoke Cypres to sell the land and invest the proceeds into an existing functional institution that serves the same targeted demographics.
Before a court will apply the Cypres Doctrine, 3 conditions must be generally satisfied. Number 1, total impossibility, impracticability, or illegality. Establish that the original charitable trust cannot be carried out according to its legal term. Common grounds include initial failure, subsequent failure, prevailing illegality, surplus funds, and inadequate funds.
The court must decide whether the settlor intended to benefit a specific institution or charity in general. Where it was decided that the specific institution was merely a vehicle to express a greater charitable intent for the help of a class of persons, then Cypres will apply if that trust fails. But where the trust was solely for the purpose of a specific institution, or there was no charitable intent, then trust fails completely if the institution cannot collect the gift. In such cases, Cypres will not apply.
Application of the Cypres Doctrine in Nigeria. Nigeria inherited English common law and doctrines of equity via the reception statutes. Consequently, the Cypres Doctrine is an active part of Nigerian jurisprudence, guided by foundational concepts seen in the Anglo-American cases that have been listed above. In Nigeria, charitable organizations and trusts are primarily regulated under Part F of the Companies and Allied Matters Act, 2020, which deals with incorporated trustees. Section 838 of the 2020 outlines the dedication of property to charitable objects. Section 850 and 5 of the same Act explicitly deals with the dissolution of corporate bodies under incorporated trustees. It provides that upon dissolution, any remaining property cannot be distributed amongst the members. Instead, it must be transferred to some other institutions similar to the objects of the association. This is a direct statutory codification of the Cypres Doctrine.
Despite the usefulness of the Cypres Doctrine in Nigeria, the practical application of this doctrine in Nigeria still faces several challenges. One is the absence of a specialized charities regulator. Unlike the UK, which operates under the Charity Commission for Wales and England, Nigeria does not have a specialized regulatory body for the supervision of charities and charitable trusts. Although the CAC, which is the Corporate Affairs Commission, oversees incorporated trustees under CAMA, it does not possess the extensive regulatory and supervisory functions needed by the Cypres Doctrine. Consequently, the courts remain the primary mechanism for resolving Cypres doctrines, which often leads to delay and procedural difficulties.
Understood the meaning and definition of Cypres Doctrine in Nigeria. One of the things we also need to know is the limitation and challenges as to the application of Cypres Doctrine in Nigeria. So what are the limitations or what are the challenges? I'm going to tell you one, and one of it is the difficulty in establishing a general charitable intention. But how is that going to suffice? We should understand that the success of Cypres Doctrine in Nigeria is largely dependent on whether the court is able to infer a general charitable intention from the application. If the court is not able to infer from the application a general charitable intention, that is whether if the application is narrowly specific or if it's discriminatory, then the application of Cypres Doctrine would fail. And if such happen, we should understand that the gift results back to the donor's estate as a resulting trust.
Weak enforcement and monitoring mechanism. Another major challenge is the absence of ineffective institutional mechanism for monitoring the administration of funds redirected under Cypres schemes. Even where courts successfully reallocate charitable funds, there is limited oversight to ensure that the receiving organization actually apply the funds towards purposes closely aligned with the donor's original charitable intention.